Hello, everyone, and welcome to the National NAGPRA Program webinar series. Today is July 1st, but this is the June webinar. We had some scheduling issues related especially to my vacation in June, and so we've rescheduled this, and I appreciate your understanding and patience as we found a good time for this webinar. Today's webinar is being recorded, so please disconnect if you do not agree to be recorded in this session. The Q&A and the chat are currently closed, but I will open them after my presentation to allow for questions and answers. Today's webinar will focus on Subpart B of the regulations. Subpart B is titled Protection on Federal or Tribal Lands, Protection of Human Remains and Cultural Items on Federal or Tribal Lands. This is a bit of a different topic and one that is pertinent, of course, to Indian tribes and Native Hawaiian organizations, of course, as is all of the regulations and the parts of the law. But the actions here that are required particularly relate to actions by federal agencies and in the state of Hawaii, the Department of Hawaiian Homelands. So that will be our focus today. This presentation is similar to a presentation that I provided in January to the federal NAGPRA network. If you're not familiar with the federal NAGPRA network, it is a community of practice for federal practitioners engaged in NAGPRA work. I've put in the chat information about if you are a federal employee, how you can join the federal NAGPRA network to get connected to the presentations and discussions that network has, as well as the resources that are available. So let me share my screen. Again, I just have a short presentation to sort of go over some of the basics of Subpart B, and then we will have plenty of time for questions and answers. So please be thinking of your questions as we go through the presentation. As all of you are aware, or if you're not, if you're joining us for the first time, there was a full revision of the implementing regulations for NAGPRA that was effective in January of this year. So we're 6 months in. And that full revision, the goal of it was to clarify and simplify the regulatory requirements. But in general, the procedures and the process are similar to the regulations that previously existed. The regulations apply to all museums, as that is broadly defined, and to all federal agencies. And I like to describe NAGPRA as having two arms, or two regulatory processes that are very different, although their ultimate goal of respectful return is the same. The first part, and what we will be focused on today, is the process for protection of human remains or cultural items on federal or tribal lands. The other process is for repatriation of human remains or cultural items by museums and federal agencies. So again, our focus for today is on Subpart B of the regulations, which is protection. The title of this subpart changed with the new regulations to better reflect what the purpose or objective of this process is. And it is to protect human remains or cultural items that are on federal or tribal lands by requiring a process. That process applies to federal agencies, the state of Hawaii, Indian tribes, and Native Hawaiian organizations. This process only applies on federal or tribal lands as those terms are defined by the law and the regulations. And the overall principle for this subpart is that Native American human remains or cultural items belong in the first instance to lineal descendants, Indian tribes, and NHOs, not to federal land managers. You can see our website there with the specific page related to these provisions. And that statement about the overall purpose of Subpart B and of the provisions in the Act itself was to make a change with the passage of NAGPRA on what happens on federal or tribal lands to Native American human remains or cultural items. This is a specific objective of Congress in creation of NAGPRA and in creating this different process and these different provisions for Native American human remains or cultural items on federal or tribal lands. This is an outline of the general sections and what's covered in each section of the regulations for the protection on federal or tribal lands. I'm going to step back here for a minute. I forgot a point I wanted to make. A lot of times people make the mistake of saying that NAGPRA only applies on federal or tribal lands. That, of course, is not correct. NAGPRA applies in two ways. One way is to protect human remains or cultural items on federal or tribal lands with this process that we're going to discuss today. But of course, NAGPRA also applies to museums and federal agencies that have Native American human remains or cultural items in their holdings or collections. So while this part and these provisions only apply to federal or tribal lands, NAGPRA, of course, has a separate process for the repatriation by museums and federal agencies. So we're going to talk through each of the sections of the regulations related to protection on federal or tribal lands. And this is just really a guide or a general outline for you to see which part, which section deals with which part of this process. So starting with 10.4 and the general requirements. The new regulations require that federal agencies, the Department of Hawaiian Homelands, as well as Indian tribes and Native Hawaiian organizations, identify appropriate officials who are responsible for this process. So all of those parties that have responsibilities under Subpart B must designate one or more appropriate officials who are responsible for carrying out these requirements. 10.4 also talks about coordination of NAGPRA with other laws like the National Historic Preservation Act, as well as others. Again, the coordination is that these laws can be coordinated, but responsibilities under one of the similar laws for preservation do not necessarily mean that you've complied with NAGPRA and vice versa. NAGPRA compliance does not ensure that you've met the requirements of other laws, but those laws can and should be coordinated to the extent that's possible. One of the biggest changes in the regulations is in 10.4, and it's not so much a procedural change as it is an organizational change. We have moved the requirements for a plan of action previously at the very end of Subpart B, now at the very beginning of Subpart B, because a plan of action, the requirements for a plan of action by a federal agency or the Department of Hawaiian Homelands is required by these regulations. And so we've put it right at the very beginning of this section. And we've outlined in 3 steps how a federal agency or DHHL, again, the Department of Hawaiian Homelands, must prepare and then approve a plan of action. Excuse me. There are 3 steps to creating a plan of action. The first is to initiate consultation. The second is to consult. And the third is to approve and sign a plan of action. The regulations provide details on initiating consultation and consulting, but also provide some basic requirements for a plan of action. And a plan of action must be approved and signed by the federal agency or DHHL official, and a copy of that must be provided to all consulting parties. In addition to a plan of action, there are options. There's an option under 10.4 for the creation of a comprehensive agreement. Much like a plan of action, a comprehensive agreement can be used to inform a federal agency as well as its consulting parties what steps, what the process will be if or when there is a discovery or excavation of human remains on federal or tribal lands, where the federal agency or DHHL has that responsibility. A comprehensive agreement can take the place of a plan of action, and it can cover a wide variety of circumstances. One difference with a comprehensive agreement is that it should be signed by the consulting parties, or at least by a majority of the consulting parties, as it is an agreement, meaning the parties have agreed to the process. So a plan of action is signed by the federal agency or DHHL official, but a comprehensive agreement would be signed by the federal agency or DHHL, as well as a majority of the consulting parties. So 10.5 and 10.6 provide the requirements for a discovery or an excavation of human remains or cultural items. And looking first at 10.5, there are requirements for any person who knows or has reason to know of a discovery of human remains or cultural items on federal or tribal land to inform the appropriate official. So there is an obligation on any person related to the discovery on federal or tribal lands. There is then a requirement for the appropriate official to respond to a discovery and to certify when an activity may resume. Prior to an excavation on federal or tribal lands, there's a requirement in these regulations for a written authorization, along with any other applicable permits prior to the excavation. And in both cases, a plan of action or a comprehensive agreement is required after a discovery or before an excavation. I wanted to highlight a little bit the requirements to report a discovery. And this is an image actually from our website. So we have this information available along with the active links here. The regulations require that any person, any individual person on federal or tribal land that becomes aware of a discovery of human remains or cultural items, and again, Native American human remains or cultural items, they must report the discovery in person or by telephone to the appropriate official, as well as the additional point of contact that's listed in this table. And this table is taken from the regulations themselves. That person has an obligation to make a reasonable effort to secure and protect the human remains, and must follow up that immediate notification with a written documentation of the discovery. And so who gets who the person reports to depends on which kind of land the discovery is on. When the discovery is on federal lands, then the appropriate official that must be notified of the discovery is the federal agency with primary management authority. And the additional point of contact is the tribe or NHO, if that can be identified. On tribal lands, and again, tribal lands as defined under NAGPRA, meaning within the exterior boundaries of a reservation. For tribal lands in Alaska and in the continental United States, the appropriate official is the Indian tribe, and the additional point of contact is the Bureau of Indian Affairs or a different federal agency if they have primary management authority for that particular tribal land. And lastly, on tribal lands in Hawaii, the state of Hawaii, Department of Hawaiian Homelands is the appropriate official, And the appropriate NHO, if known, is the additional point of contact. There's one exception in the law itself for federal lands in Alaska that are selected but not yet conveyed under ANCSA, or the Alaska Native Claims Settlement Act, and that's in the last row here. This table in the regulations, as well as on our website, is aimed at helping people understand who to contact if a discovery is made, and how to identify those contacts. So on our website, we have linked to a USGS web map called the Protected Areas Database. So I'm going to go back for a second. If you were to click on the federal lands here that's highlighted on our webpage, it would take you to the Protected Areas Database and would help you to identify where you are and who is, if you are on federal land or if you are on tribal land. And we're pleased to say that it also includes an indication of Hawaiian homelands as well. So again, just another tool that's available to help people identify if they are on federal or tribal lands, and to be able to then report that to the appropriate official. I'll add that there are contact lists that we've linked to in these sections to help with identification of those appropriate contacts there. This part of the law and the regulations can seem pretty daunting. It can maybe seem a little confusing in an abstract of this regulatory language, or even in this attempt at being a user-friendly table of identifying land and contacts. But the purpose, the overall purpose of the regulations and of this information on our webpage is really to follow those requirements of the law itself to ensure that anytime a discovery is made on federal or tribal land, that there is an obligation for the person making that discovery to report that. This can take a lot of different forms, and I could spend quite a lot of time providing you with sort of hypotheticals for each of these scenarios. And there are plenty of examples of discoveries on federal or tribal lands and how they were reported. The effort here is to clarify those responsibilities on the person, as well as to provide some assistance in identifying the location of land and who needs to be reported. If you have specific questions about this or the process for reporting on federal or tribal lands, we can discuss that in the Q&A section. More often than not, discoveries on federal lands, sometimes tribal lands, but definitely federal lands, can be related to an activity. An activity on federal lands could include lots of different things, but in particular, the law points out that the activity might be construction, mining, logging, or agriculture occurring on federal lands. When a discovery is related to an activity like that, then there is an obligation for the activity to stop if it could threaten the discovery, for the discovery to be reported, as we discussed previously. And in response to the discovery, a written documentation of the discovery is required, and the activity must stop and may not resume until the appropriate officials issues a written certification. So again, this is the procedure that's laid out by the Act itself for stopping an activity on federal land when it is related to a discovery. The regulations try to provide a clearer process for implementing that statutory requirement. This was the subject of many comments that we received during the proposed rule process. And in particular, I wanted to point out comment 81 and comment 82, which you can read in full for yourself in the final rule. But in this instance, we received comments requesting that we extend the timeline for a work stop to an indefinite timeline. And then we also received comments that say that requested that we not extend the timeline beyond the 30-day period. That again, we've sort of expressed these here in this slide as the floor and the ceiling for a work stop. So some comments asked us that we make 30 days the floor and have no ceiling, so an indefinite timeline for work stop. On the other hand, other comments requested that we make 3 days the floor and 30 days the ceiling. So in response to both sets of comments, the department's response and what is in the final rule is that 3 days is the floor. So a maximum of 3 days work must stop on federal land, or a minimum of 3 days to complete the documentation. But that work stop could be extended as long as 60 days if there is a discovery. Obviously, this all depends greatly on the circumstances of the discovery, and work could resume as quickly as 3 days after a discovery. We have provided in the regulations 30 days for a federal agency or DHHL to evaluate the discovery and to ensure consultation on the discovery and to complete the plan of action. And an additional 30 days to carry out that plan if needed. So again, that's where we get to the 3 days as the floor and 60 days as the ceiling in the final regulations. You can read more about our reasoning for this in our response to these comments. So again, just to look at the timelines for responding to a discovery. When a discovery is made, an appropriate official must respond within 3 days, and there are certain tasks in the regulations that are required by the appropriate official. Within 30 days of being notified of a discovery, the appropriate official must approve and sign a plan of action, and also send a written certification that identifies the date on which an activity can resume. Moving on to section 10.6 relates to an excavation. An excavation may be needed either after a discovery is made or independent of a discovery. Either way, if an excavation is needed, the excavation of human remains or cultural items on federal or tribal lands, then there's a requirement to authorize the excavation in writing. In certain cases, a permit under Section 4 of ARPA may be required on certain federal or tribal lands. And in this section of the regulations, we've divided the process into what must occur on tribal lands and what must occur on federal or tribal lands. So the difference here is, of course, on tribal lands, when an Indian tribe or Native Hawaiian organization has responsibility for the excavation or authorizing the excavation, then they must consent in writing by providing a written authorization. The law requires consent on tribal lands from an Indian tribe or NHO, and this is how the regulations provide that process through a written authorization. Now, on federal lands and on tribal lands where a federal agency or DHHL has responsibility, rather than an Indian tribe or an NHO. So in those cases where a federal agency or DHHL has responsibility for the excavation, then a plan of action is required in addition to the written authorization. In general, the regulations try to be very clear that a plan of action is only required when a federal agency or DHHL has responsibility. A plan of action is not required when an Indian tribe or NHO has that responsibility. And so that's why we've distinguished the process here, depending on who actually has responsibility for the task, whichever that is, and in this case, the excavation. The final section of these regulations for protection on federal or tribal lands deals with disposition. And disposition is a defined term under the regulations. It's been a term that's been used throughout the NAGPRA regulatory history, but we've tried to clarify the distinction between disposition that applies in in Subpart B, excuse me, versus repatriation, which occurs in Subpart C. So we've distinguished those two terms, and we use only disposition in Subpart B of the regulations. So the Act itself provides a priority order for disposition for human remains or cultural items that are removed from federal or tribal lands. The first priority goes to known lineal descendants. The second priority is to Indian tribes or NHOs from whose tribal lands the human remains or cultural items were removed. And then following that is the closest cultural affiliation, followed then by federal land that is recognized as Aboriginal land. And there are two options under this circumstance where the federal land is Aboriginal land of a tribe, and it may be the Indian tribe that is recognized as Aboriginally occupying the location, or it may be a different Indian tribe who can show by preponderance of the evidence a stronger relationship. Again, this comes directly from the Act in terms of the priority. The regulations have added and clarified that the fifth and final priority order is with any Indian tribe or NHO that may request transfer of human remains if they are unclaimed. And we'll talk about what unclaimed means in a minute. So again, this is the priority order for disposition that is laid out in the Act itself and reiterated in the regulations in 10.7. Disposition process, again, is divided between which kind of land and who has responsibilities. So on tribal lands, where an Indian tribe or NHO has responsibilities, they are required to identify who has priority and to complete and retain a written disposition statement. This is intended to be a simple process by which the Indian tribe or NHO records for its own records who has priority and the disposition. This may be a pretty simple process, and it's intended to be a very simple process to include a record of the disposition on tribal land by the Indian tribe or NHO. There's no additional requirements here. Again, much like the excavation provisions that we discussed, a written excavation authorization from a tribe provides the consent. Here, a written disposition statement provides a record of the decision by the Indian tribe or NHO on disposition. There is more process and more requirements where a federal agency or DHHL has responsibility for disposition. In those cases where the federal agency or DHHL has responsibility, there's a 5-step process for disposition. The first step involves notifying or informing consulting parties that human remains or cultural items have been removed. Next comes a notice of intended disposition, followed by a claim for disposition and a response to the claim, and then ultimately a disposition statement. Those of you who are familiar with the repatriation requirements in Subpart C will hopefully see this as a similar step-by-step process, a similar process that applies on federal or tribal lands when a federal agency or DHHL has responsibility. So what about human remains or cultural items that were removed from federal or tribal land between 1990 and 2024, but whose disposition is not complete? This is an issue that came up during the proposed rule comment process. how to deal with any human remains or cultural items that this subpart applies to, but whose disposition may not have been completed by the time of these new regulations. So we have included a requirement for federal agencies or DHHL to complete the first step in the disposition process within just a few days now, by July 12th, 2024, to notify those Indian tribes or NHOs with priority for disposition of those human remains or cultural items that have not completed the process. And the idea is then this will start the clock for those objects to be able to complete their disposition by following the step-by-step process in the new regulations. We know that there are instances where human remains or cultural items were removed from federal or tribal land, but their disposition has not been completed. And there are a variety of reasons for that. And we wanted to ensure that these regulations had a way for the federal land manager or DHHL to complete those steps. And then the last section of Subpart B deals with what happens if no party can identify or there's no claim that is received. And this is what is termed unclaimed human remains or cultural items. Again, this only applies to federal or tribal lands. And there are two ways that human remains or cultural items might become unclaimed. And that is 1 year after a discovery, if no priority for disposition can be identified, then those human remains or cultural items would be unclaimed. Or 1 year after publishing an NID, if no one submits a claim for disposition, then those human remains or cultural items would become unclaimed. Where items are unclaimed under these regulations, then they are required to be reported. There's a requirement to report unclaimed human remains within 1 year of the final rule, which is January 13th, 2025. And then there should be updates from federal agencies or DHHL every December 31st after that. Again, this is not a new requirement, but we've clarified the timeline here so that there is a clear requirement for federal agencies and DHHL to ensure that they've properly reported any unclaimed human remains or cultural items. There are options under the regulations for the transfer or reinterment of those unclaimed human remains or cultural items, and those require a notice of transfer or reinterment, a new notice type we're calling NOT, which will be published in the Federal Register. So again, this is not necessarily a new process, but we've tried to clarify and simplify the steps and the timelines associated with unclaimed human remains or cultural items. So this has been a very brief, although it feels at times quite extensive, overview of the requirements in Subpart B. And I wanted to highlight for all of you where you can find more in-depth discussion about these topics, and in particular the comments that we received on the proposed regulations and our detailed responses to them. There is a section of the final rule that deals with parts that are applicable to both Subpart B and C, primarily consultation. Issues around consultation and physical transfer are addressed in the final rule in comments 64 to 67. And then from there, section 10.4, the general, especially around the plan of action, there are comments from comment 68 to 72 to go in more depth on that. And then you can see in 10.5, comments 73 to 82, respond to that section for discoveries. Comments 83 to 85 cover the section 10.6 excavations. And finally, comments 86 to 91 deal with 10.7 and disposition. Again, we received a large number of comments, as you can see, and on this part in particular, and we have prepared extensive responses to those comments. So a lot of times I find that the questions people have, answers can be found in the final rule. It can be a little hard to find where to look, which is why I've provided this for you as a means of assisting you in navigating the final rule. In addition, I wanted to again reiterate that we have updated our webpage to reflect the regulation changes, and we've tried to clarify and simplify even further the regulatory language in our website language. So we use a formula of questions and answers throughout our website, but in particular, you may find it useful to look at the pages on protection on federal or tribal land, and then the related sub pages about discoveries or excavation, about unclaimed, and so on. That information can all be found on our webpage. And lastly, I'll just mention that we have developed several templates related to protection on federal or tribal lands. You can see those here. We are still working on a few, but intend to have those available. And yes, if you have any specific needs related to templates that are not available, you can always reach out to us at the National NAGPRA program. So with that, I'm going to stop sharing. And I'm going to hopefully remember how to allow for questions. Okay, I've opened the Q&A for this session. Remember that you can enter your own question, or you can upvote questions that are asked by others in the Q&A section. All right, I see we have a question that is actually unrelated to the topic of today's webinar, but I will go ahead and read it and answer. The question is, would I be able to comment on the letter sent out to museums, universities, etc., from Senator Brian Schatz? What's my opinion of this letter, and do I have any advice for those preparing responses? I appreciate the question. However, I don't have any comments. I've actually not seen a copy of the letter, although I have certainly heard about it. Therefore, I don't have any comments or really advice. I'd say the advice is to answer the questions to the best of your ability. I will say that this is the second round of letters that have gone out, or second or third, actually. There were letters that were sent out last year in 2023. And we actually provide on our website those letters as well as the responses. So for those of you who are maybe unaware of that, or the activity around this from last year, so April of 2023, you can find a copy of the letter as well as those responses. In that case, there were 5 letters and 5 responses, and I will put that in the chat. It is on our law page. If you scroll down, you can find those comments and responses. Just a reminder, please ask your questions in the Q&A. We aren't able to manage the live questions and answers at this time. So please don't raise your hand, but please put your question in the chat. All right, we have several questions. Next question, again, we are a private university that receives federal grants, Pell Grants. Are we subject to NAGPRA? The answer is yes, likely. That is a decision that you need to make, your institution. needs to make, but very likely the federal grants through Pell grants indicate federal receipt of federal funds for purposes of NAGPRA. Okay, I'm going to see what's getting the most votes. Again, a reminder that you can upvote questions. And I have here a question. Again, I'll try to indicate when these questions are not related to the subject of today's webinar. That doesn't mean you shouldn't ask them. Feel free to ask whatever questions you want. I want to be very clear, and sometimes there's a lot of confusion around the two different processes in NAGPRA, and I want to be very clear when the question relates to repatriation, which is not what we've just discussed. So the question that has the most upvotes right now is a case example. A museum in Alaska has tribal human remains that were collected in the 1890s, before Alaska was a state and before it was even United States territory. The land that the remains came from are today owned by a tribal village. If a federal agency cannot be clearly identified in the process, am I assuming the museum can consult with the tribe and proceed with the repatriation process? This is a good question, and it gets to actually a question of possession or control, and who has possession or control of this collection that predates Alaska statehood and actually predates U.S. territory status for that land. You would perhaps want to ask the federal agency if they have any insight into this, and if the federal agency has any possession or control questions. And there are some cases, and I can't speak to this case specifically, or even Alaska, but you want to be sure that you've at least reached out to the federal agency that may have an interest, although in this case, maybe you can't even identify that interest, that federal agency. Therefore, the museum should consider that it has possession or control of that collection and should proceed with the repatriation process. We tried to outline these kinds of issues in 10.8 of the regulations, which explains ways that museums or federal agencies may have possession or control. And in cases where a museum determines that a federal agency actually has possession or control, there are requirements in the regulations for the museum to notify the federal agency. Another option is where a museum cannot identify any other party with possession or control and does not believe it has possession or control. That should also be reported to the National NAGPRA program, and that is in 10.8D, and I would encourage you to take a look at that. All right, the next question is, for human remains removed on federal lands, do the federal agencies defer to tribes as to what must be done with the remains? Can you expedite the return so two government agencies aren't slowing down the process? Is it in the Fed's best interest to defer? The notice process is slow working with federal agencies. Yeah, thanks. This question does apply to Subpart B and the protection provisions on federal or tribal lands. So when human remains are removed on federal land, federal agencies have obligations, and those obligations for disposition, as we discussed, is a 5-step process. And that includes the notice of intended disposition. We are hopeful that with greater clarity, easier templates, that federal agencies can move quickly through these 5 steps of the disposition process. We are also always available to help a federal agency with completing those steps. While we have timelines attached to those steps, for example, the first step of informing consulting parties that items have been removed must be done no later than 6 months after the removal, it could be done much faster. So again, I think it's important to remember the timelines that we've included in the regulations are often a no later than to ensure the process is moving forward. But certainly there are ways in which the disposition process, the 5 steps of the disposition process, could move very rapidly. And we are always available to help federal agencies figure out how to be as expeditious as possible in that process. We do think that it's in the best interest of everyone to move through the disposition process as quickly as possible, and to ultimately realize that the overall goal here of this section, which is to ensure that the Indian tribes or NHOs have, in the first instance, the rights, the full rights to make decisions related to those human remains or cultural items that are removed from federal or tribal lands. I hope that answered the question. Gonna refresh and see what comes to the top. All right, this question kind of crosses both subparts, so I'm going to read the question and then try to clarify it a little bit. What constitutes possession? If remains are in situ and need to be removed and repatriated from an eroding shoreline to a site several hundred feet inland, does NAGPRA really apply? Let me say that this is not on federal, but state-owned land. Okay, well, thanks for the question, and thanks for an opportunity to show how a lot of times what we have to do is pick apart the questions to kind of get at what the answer is or where to find the answer. So in this case, possession or control is the central question for purposes of the repatriation sections in Subpart C. And where we're talking about remains in situ that need to be removed because of erosion. And we're talking here about state land. So not federal land, not tribal land, but state-owned land. Then the state needs to determine if it has possession or control. Any activity with movement of those human remains, even from an eroding shoreline to another site several hundred feet inland, could be an exercise of possession or control and would therefore trigger NAGPRA responsibilities for the state in making a decision. Sometimes the easiest way to understand this is to think about decision making, right? So if the state is deciding that it's going to move these remains from one place to another, it is exercising some control over those human remains, and therefore it needs to consider, the state needs to consider what its NAGPRA obligations are. And by that, NAGPRA is going to clearly require tribal consultation. So any state that we're considering a similar kind of activity would need to be sure that it's consulted with the appropriate Indian tribes, and need to look a little closer at the authority by which it's taking this activity. So I guess my answer to you is be sure you're asking the questions about whether NAGPRA applies, because it very likely may apply, depending, of course, on the circumstances in your state and the state law. And that's where these questions are best posed to a lawyer for your state, generally, an attorney general, or some other legal advisor for your state. And often these are issues that need to be addressed or considered by either the state archaeologist or the State Historic Preservation Office. So often if you're not engaged with those offices within your state, that's probably also a good place to start to try to get the answer to this question. Another question here, does NPS have a template for notices regarding repatriation of objects of cultural patrimony? Yes, we do. Repatriation of a notice, repatriation of an object of cultural patrimony would be done through a notice of intended repatriation. So that is the template that you want to look for, and we have that available on our website. And just follow up there. I think the question ends with what medium is considered sufficient. So the medium for publication of notices for public notices under NAGPRA is the Federal Register. So that is where notices should be published. Okay, I see we're getting lots of upvotes. I see we're also getting some answers, and apparently this is not sorting. Let me try to switch my view. All right, there's a question that was answered already in the chat, but I'll go ahead and read it for anyone who's only listening. Do you have any comments about how the Chevron decision could affect NAGPRA in the final rule? The answer came from Stephen Simpson, who said the Interior Office of the Solicitor is reviewing the decision from the Supreme Court, but does not anticipate any revisions to the NAGPRA regulations. And Stephen notes that the decision is available on the Supreme Court's website. Thank you, Stephen. Okay, here's a question related to the topic for today. How is priority for disposition determined when multiple tribes have cultural affiliation? Can priority for disposition be based on one tribe's willingness to move forward on disposition on behalf of the other tribes? Thank you very much for the question. The answer comes in the language that's used in the law, and as I said, reiterated in the regulations in 10.7, paragraph A, and that is the priority for disposition is in the third priority is the Indian tribe or NHO with the closest cultural affiliation. So, how is that priority for disposition determined when multiple tribes have cultural affiliation? Well, there are a couple of options for the federal agency in this case, and I would say that the answer to your question really depends and hinges on consultation, as the answer to all questions under NAGPRA, consultation. So if in consultation, in consulting with all the tribes who have potential cultural affiliation, then the federal agency can determine that all of the tribes are culturally affiliated and proceed with the notice of intended disposition and through the process by recognizing all of the tribes have cultural affiliation. If a case comes where there are competing claims for disposition, and I want to be sure I'm using the correct language. So if there are multiple competing claims for disposition, then the federal agency would need to look at who is the closest culturally affiliated tribe to determine the most appropriate claimant. But again, in the first step, in the first instance, the federal agency could determine that all of the tribes with cultural affiliation should be listed in the notice and should be notified. And whoever then makes a claim for disposition would be who the disposition goes to. And it's only in those cases where there are competing claims for disposition that the federal agency would need to determine who is the closest culturally affiliated tribe. So this is a very common question in both Subpart B and Subpart C. And my advice to federal agencies or museums is don't anticipate the conflict. Take these steps as required and make the decisions that are required. And if or when there is a conflict, a competing situation, then we've provided advice for how to resolve that. But don't get too far ahead of yourself in anticipating the conflict. What are some of your recommended materials to teach non-archaeologists and other unrelated professionals about NAGPRA, especially with the new regulations? Thanks for the question. I tried to address this in the May webinar series by sharing some of our videos from the National NAGPRA program that were created 14 years ago. Even though they were created 14 years ago, they're still excellent resources to use, and especially to convey information just generally about what NAGPRA is, why it was necessary in 1990. So where videos are an appropriate medium for that recommendation, then I would definitely recommend any of the NAGPRA videos that you can find on the National NAGPRA Program's YouTube channel. Aside from that, if you're looking to teach non-archaeologists or other unrelated professionals about NAGPRA, there's no better resource than the law itself. And as much as it may be not the easiest thing for to read, I still think that reading the law, which is relatively short, is the best foundation for understanding what is required. Beyond the law itself, of course, reading the regulations is on the top of my list. For the new regulations, looking at particular comments and responses in the final rule provide a great education. For example, if you're interested in talking in a class or other setting about the duty of care requirements in the new regulations, then assigning students to read the comments and responses related to that duty of care requirement is a great place to start, because the comments and the responses are going to go into what the law itself says, what the regulatory history is, the summary of comments that were received through tribal consultation and on the proposed rule. So there's obviously I'm biased here, but I think there's a lot of value in reading the comments and responses in the final rule itself. Okay. Again, a reminder that you can put your questions in the Q&A, and you can upvote questions that other people asked. The next question relates to the topic for today, so protection on federal or tribal lands. Are there instances where there's a discovery of remains on federal or tribal lands and the party that is determined to have authority over those remains wishes for the remains to be unexcavated, stay in the ground? Do they have authority to stop the removal? Great question. In some cases, yes. In some cases where there is a discovery of human remains or cultural items on federal and certainly on tribal lands, then the Indian tribe or Native Hawaiian organization, if they wished for those human remains or cultural items to stay where they are, then that is an acceptable outcome of a discovery and would in fact end the NAGPRA process. So when a discovery is made, the plan of action would be needed, and hopefully the plan of action would be in place before the discovery occurs. But the plan of action would dictate what the tribe's preferences are, and it may be for not removing those human remains or cultural items. And where the federal agency, in the case of federal lands, can accommodate that request, then that's certainly an acceptable outcome. Now, we all know that federal land managers may not always be able to agree with that request. There may be other reasons why the activity has to resume, why the human remains cannot be protected in place. And in those cases, then an excavation would be required and the disposition process would be required. Again, we did try to address this in the final rule. We have some more specific examples that we provided in the final rule related to this. And if I look back at my PowerPoint, I can tell you which comments to look at for some examples. So if you were to look at comments 68 to 72 in the final rule, you will find some, as well as before that, I'm sorry, on plan of action, comments 68 to 72, you'll see that we've provided some examples for how this might occur and what a plan of action might look like that would not result in removal of remains. And again, it all hinges on the ability of the land manager to agree to that, but certainly an option. The next question is, it looks like, okay. A good question here. I think I'm going to answer, I'm going to assume that it's related to subpart B and protection. So in cases where a federal tribe has not made a claim for human remains, I'm going to say removed from federal or tribal land, then after a time period, can state tribes repatriate those remains in the state? So non-federally recognized tribes or Indian groups without federal recognition, can they repatriate? The answer is no, not directly. And we're actually going to talk more about this at the next webinar, the July webinar, which is scheduled for July 19th. We'll focus on Indian groups without federal recognition and how they can participate in repatriation under Subpart C. Under Subpart B, there's even a more restricted participation, although in some ways, again, across the regulations, these federal regulations, they really highlight the rights of federally recognized tribes to this process, whether it's disposition or repatriation. So the answer is no. An Indian group without federal recognition could not receive direct disposition under Subpart B or repatriation under Subpart C. That doesn't mean they're excluded from the process entirely. And as has always been the case, Indian groups without federal recognition can work collaboratively with federally recognized tribes to achieve their goals, but that partnership is a requirement. So we'll discuss this more, though, in just a few weeks on July 19th. Okay, for previously excavated materials, can you talk more about how an agency can understand whether Subpart B or Subpart C applies? Is the discretion about whether ancestors or cultural items have been formally accessioned by the agency or something else? Excellent question. Thank you so much for asking it. One we get quite often. And I will say that we tried to, again, provide guidance in the revised regulations in 10.8. In particular, 10.8B talks about how federal agencies may have possession or control of human remains or cultural items for purposes of repatriation. So it isn't, it has nothing to do with accessioning. Let me just say right out, possession or control and how that is defined under NAGPRA has nothing to do with a formal accessioning by an agency. In the case of federal agencies and whether Subpart B or Subpart C applies, the determining factor is when the human remains or cultural items were removed. If they were removed before November 16th, 1990, then from federal land, then Subpart C is going to apply. If they were removed after November 16th, 1990 from federal land, then Subpart B is going to apply. So it's a pretty clear distinction there, and we've tried to clarify that in the regulations. Now, there are some exceptions there. There may be some confusion over where human remains or cultural items were removed. And in those cases, then the federal agency needs to make a decision about whether Subpart B or Subpart C applies. I hope that was helpful. Okay, let me resort. All right, the next question. Can you confirm the comment from the preamble that tribal jurisdiction for these provisions apply to all lands within the exterior boundaries of a reservation, including all non-trust lands consistent with McGirt v. Oklahoma, as well as trust lands outside the exterior boundary, consistent with Oklahoma Tax Commission v. Citizen Band Potawatomi Indian Tribe? Thank you for the question. I can confirm that the definition of tribal land under the regulations is all land within the exterior boundaries of a reservation. I would need to look more closely at the preamble to see if we discussed the application of McGirt v. Oklahoma or Oklahoma Tax Commission v. Citizen Band Potawatomi Indian Tribe and those particulars expressed here. I can't recall off the top of my head. I can recall most things off the top of my head, but that's a little bit more specific. I can say that and confirm again that the definition of tribal lands under NAGPRA is all lands within the exterior boundaries of a reservation. Okay, the next question is for 10.8, we believe we know our federal agency collections, but what is the consequence or process if an additional collection is discovered after the January deadline? How much detail should we include in the description in letters to federal agency? Okay, thank you very much. So this question relates to the requirements in 10.8C, where museums with custody of a federal agency collection must notify the federal agency of that collection. Again, the question is that the museum in this case believes it knows which are federal agency collections, but what is the consequence or process if an additional collection is found later? The overall goal of 10.8C is for museums to identify all federal agency collections that are in their custody. In terms of what the consequence or process is, that's again would be a very case specific issue, and it would depend a lot on what the museum knows. So a museum is required under 10.8C to look at the information it has and to try to identify all federal agency collections and then report those. And then the follow-up there is how much detail should we include in the description? We have a template for a written statement from a museum to a federal agency available on our templates page. That is the minimum detail that's required, but certainly you could add more detail. The more information you can share with the federal agency about the collections that you hold, probably the better off all parties are in that process. So we would encourage you to include detail and information, or at least offer to provide additional information. Hopefully that helps. Okay, let me resort. Lots of questions here. I'm trying to get to as many as I can. Okay, on 10.5 table 1, if a federal agency contractor makes a discovery on federal land, does the contractor immediately notify the tribes as well as the federal agency? Or is immediate tribal notification the responsibility of the appropriate official? And Stephen, again, from the solicitor's office, has helped out here. The notification is the responsibility of the discoverer. The contractor would notify both the tribe and the federal agencies and the federal agency. Yes, and I would just add to that, well, there's some follow-up questions. I work on an Air Force base, and it's our information for contractors that if they make a discovery to stop work, notify the contracting office and cultural resource manager. Should we update to include that they should be notifying tribes? That seems confusing. Somebody else asked if this question was answered. Okay. So any individual that makes a discovery, including a federal agency contractor, who makes a discovery on federal land must report that to the federal agency official. They must also report the discovery to an additional point of contact, being the Indian tribe, if that is known to the person making the discovery. And I think that the follow-up here about the details for a contractor are where a federal agency can specify both the appropriate official for the federal agency, but also if there is an additional point of contact that should be notified. So again, there is a requirement for the federal agency to notify Indian tribes in its response to the discovery. So that is a secondary notification, but there is an obligation here for the discoverer, which is a difficult word, the person making the discovery, to notify the additional point of contact if they can identify that additional point of contact. And I will add that I appreciate the follow-up question, because certainly any federal agency that is working with a contractor should include some provisions and information about what should happen if there is a discovery. Okay. All right, we just, well, we've answered more than we have left to answer. So that's a positive sign. We have about 20 minutes left. The next question, what is the protocol when civilians find and take cultural items from tribal land and want to return them? This is a good question. It's a difficult one, and it relies a lot on some very specific issues involved. So if a civilian were to find and take cultural items from tribal land, then they should contact that tribe as soon as possible. They had an obligation to report that discovery immediately, and they have an ongoing obligation to report that discovery, assuming that this occurred after 1990. And I would encourage the citizen, in this case, the person, to start immediately by working with the tribe from whose tribal land that was removed. I'm going to leave the answer there because a lot of it's going to depend on other particulars, what kind of cultural item we're discussing, and the tribe's response to that. But certainly the citizen has an obligation to report that discovery to the tribe, and then the tribe has an obligation to respond to that discovery. I will add that there is a statement in the regulations that clarifies that in responding to a discovery, the appropriate official, whether for the Indian tribe in this case or other federal agencies or DHHL, they must comply with the requirements of the section on discoveries as soon as they learn about a discovery, even if the discovery was not properly reported. So there's still an obligation on the appropriate official to make a response. Okay, resort. If I have a plan of action in place, again, a question that relates to our topic for today. If I have a plan of action in place and notify tribes in writing the same day, do I still have the 3-day work stoppage, and why? If a discovery occurs, there's a plan of action in place, and the tribes are notified the same day, then there's not a requirement for a 3-day work stoppage. It is no later than 3 days that the appropriate official must respond to the discovery. I will add that before the activity can resume, the appropriate official must send a written documentation certifying that the activity may resume. So if all of that can occur in one day, or in the same day, then certainly it wouldn't take 3 days. However, we do provide at least 3 days for the appropriate official to respond to the discovery. And that includes securing and protecting the human remains or cultural items, verifying that the activity is stopped, and notifying the additional point of contact. So if you have a plan of action in place, you notify the tribes and you're clear on the security and protection of the discovery, that the activity has stopped, you can move forward with the written documentation that the activity could resume. But again, the option here is to take the 3 days to ensure that those pieces are in place and to ensure that no further damage will occur to the discovery. In this case, it's going to depend a lot on the specifics of the discovery, how quickly the process could move. Right. The next question is, since the new law updates what is considered NAGPRA, are there 2 efforts, pre-1990 items that need to be reconsulted, and the second would be post-1990 items? So first of all, let me step back and clarify that the new regulations don't change what is considered to be a funerary object or sacred object or object of cultural patrimony. Rather, the new regulations clarify how the decisions are made by museums and federal agencies about what kinds of objects can be repatriated or are available for disposition. In terms of pre-1990 and post-1990, that really only applies to federal or tribal land. So how a federal agency or the Department of Hawaiian Homelands deals with human remains or cultural items removed from its land is going to vary if the removal is before 1990 or after 1990. For museums, there is no 1990 distinction between a museum collection, holding or collection. Rather, all human remains or cultural items that are in the possession or control of a museum are subject to NAGPRA, provided, again, that they meet those definitions of funerary objects, cultural patrimony, or sacred objects. In terms of requirements to reconsult, there is an obligation for museums to initiate consultation on any human remains or funerary objects that have not been published in notices of inventory completion. Under the new regulations, that requirement must be completed within 5 years. So by January of 2029, museums must initiate consultation on human remains or cultural items in their control. I hope that answers the question. Please feel free to follow up if not. Okay, the next question is, we are a public college that receives federal funds. We do not have a museum. However, we do have collections from archaeological field schools. There are no human remains or artifacts associated with human remains, but we do have indigenous artifacts. Are we subject to NAGPRA? And thanks for those of you who answered. Yes. Although you don't have human remains or associated funerary objects, you would still be required to submit a summary of cultural items that may be subject to a request for repatriation. It sounds like you want to follow up with some more questions. You're welcome to reach out to us at the National NAGPRA program. We can be reached at nagpra_info@nps.gov. That's our general inbox, but we happy to receive your additional questions there, and we can provide you with more. You might also want to take a look at the pages of our website related to summary of cultural items. or repatriation of cultural items that give you information about a summary. Okay. This applies to notices in general. However, my specific example is a notice of inventory completion published in today's Federal Register by the University of Georgia. The NIC identified the site trinomial without naming the state or site. While it is possible to identify the state and county through the trinomial, it will not be easy to have the NIC appear in a search for county or state. Searching for states and counties helps inform ongoing NAGPRA implementation. And then there's a correction that NIR, Notice of Intended Repatriation, rather than a Notice of Inventory Completion. So in a Notice of Intended Repatriation, there is, just want to check this. There is a requirement to include an abstract of information from the summary. And information in a summary can include geographical location by county or state. But there may be cases where that information is either not available, although it sounds like in this case, there was a trinomial identified indicating geographic location, but it was not called out in the abstract in that section of the notice. The content of a notice, in particular the content of the abstract of information section, is the responsibility of the university. If you have questions about that information, you can contact the University of Georgia directly. The National NAGPRA program does not closely review the content of the abstract of information. We depend upon museums and federal agencies to include the required information in their notice. I think that the question of the lack of information in this particular notice would be best to contact the university itself to get that additional information. Okay. Let's see. Next question is, will it be incumbent upon states to develop similar guidance when federal lands and or federally recognized tribes are not involved? Thanks for the question. I think this goes to sort of similar to the question before about a discovery on state lands. It is certainly incumbent upon states to develop processes or laws for how the state manages discoveries of Native American human remains or cultural items from state or private land. Most states have some form of a burial law that would include this kind of procedure or process for state or private land. And many of those state laws provide specific direction on a process. And there are certainly examples that you can find of how states have managed that, but it is up to a state to identify and determine what happens to archaeological resources in general on state or private land. And for Native American human remains or cultural items, certainly the added issues of NAGPRA and how NAGPRA compliance fits with that state requirement is important. I will note that we did a webinar on this issue many years ago. We've done several, but I think that there's still a recording available about state laws related to NAGPRA. Again, it's going to depend a lot on the particular state. All right, the next question is, if a discovery is made there is a project nearby, but the project is being modified to protect, does the federal agency have to excavate due to the proximity to the project? Previous best practices were to leave items in situ. Is that still the case? Absolutely, leaving items in situ, provided that the federal agency can protect them, and that the tribal consulting parties agree, is absolutely acceptable. There is no requirement in NAGPRA for excavation. Let me just say that again. There is no requirement in NAGPRA for excavation. However, when excavation or discovery on federal lands results in removal, then there are requirements under NAGPRA. So removal is not required, but if removal occurs, then there are certain requirements. Okay, let's see. I'm getting close. Let's see if I can get through the last few here. Okay, can a federal agency with land management responsibilities satisfy the plan of action requirement by becoming a signatory to a different federal agency's plan of action developed for a specific project that will be carried out on land managed by by the first federal agency? Whew. Well, I should have, this is a complicated one for the end of my hour and a half, but I'll do the best I can. If the consulting parties agree to the plan of action that was previously developed, then that plan of action can be modified and apply to a different federal agency project, whether within the same federal agency or within different federal agencies. In addition, remember there are options for comprehensive agreements which can cover broader areas, involve broader projects, and could involve multiple agencies. The answer to this is really going to come down to agreement by the consulting parties, one, and agreement by the federal agency officials that this satisfies their needs. So a plan of action could be replicated in many ways in many locations, provided all the parties are in agreement to that. So certainly you can look to plans of action that were developed in other places to apply to your project and your federal land. But again, the circumstances may be different, and so it's important to be sure that the consulting parties are in agreement. Follow up on the question around notices, would the National NAGPRA program consider requiring institutions and agencies to include state and county when known in notices to aid with the federal register searches? Again, the requirements are in the regulations to include a summary of the information, which includes geographic information in the notice. If the question is the National NAGPRA program going to review each notice and check for that information? No. We depend on museums and federal agencies to ensure the accuracy of their notice and that the notice includes the information that is required. And again, we would encourage you to reach out to any university or museum if you feel there's information lacking in their notice. Last question. Is the following correct? The law defines two kinds of associated funerary objects. Objects that are related to human remains that are removed and the location of the human remains is known. B, objects that are made exclusively for burial purposes or to contain human remains. That is correct. So objects that are related to human remains that were removed and the location of the human remains is known is one way of identifying associated funerary objects. In addition to that, the law clearly states that objects that are made exclusively for burial purposes or to contain human remains are associated funerary objects. Even if, say, the pot that was created to contain human remains no longer contains human remains, yes, that is an associated funerary object. So you are absolutely correct, and I appreciate you laying out the two ways that an object may be an associated funerary object. I did it with 1 minute left. So again, thank you all for joining me today. Thank you for your questions. Thank you for your attention and your interest in this topic and in NAGPRA in general. And we look forward to seeing you in just a few weeks on July 19th for the next webinar. Thank you.